for Edmonton, Strathcona, followed by the Leader of the Liberal Party.
Thank you very much, Mr. Speaker. I'm pleased to be able to get up to participate in the debate around my motion 502, I think it is. Let me begin by just cleaning up the name of lawyers. I'm the fourth lawyer involved in this debate, and I will now be the lawyer that does not agree with the other three lawyers. I am very much opposed to this motion, and I urge my colleagues in this House to reject this motion. I'd like to begin. We've been talking a lot about what the Court of Appeal in Alberta has said, but more recently in 2013, the Supreme Court of Canada ultimately had to render a decision on similar legislation in Saskatchewan as a result of activities by a fellow named Whatcott, who's also, of course, spread his joy in Alberta as well. And in the course of doing that, the Supreme Court said as follows: hate speech may often arise as part of a large public discourse, but it is speech of a restrictive and exclusionary kind. Political expression contributes to our democracy by encouraging the exchange of opposing views. Hate speech is antithetical to this objective in that it shuts down dialogue by making it difficult or impossible for members of the vulnerable group to respond, thereby stifling discourse. Free speech is important, but not to the extent that it infringes on anyone else's ability to feel safe or secure. So that is what the Supreme Court of Canada has said about this issue. Now let's put this motion coming from our friends over there in the official opposition in context. This is part of what I would say, this is the third plank, I would argue, of a three-plank effort thus far through the combined efforts of this Conservative government and the Wildrose opposition to undermine human rights in this province. In 2008-2009, we had the introduction of 11.1, that amendment to the Human Rights Code, which in my view continues to be a scar on the Human Rights Code in this province. It is unique in the country. It is discriminatory itself, and only in this province do we have it. And that came as a result of folks over there in the Conservative Party listening to their more extreme factions. Then after that, right on the eve of the last 2012 election, we had a debate over whether or not our Education Act could possibly be so offensive to Albertans so as to include reference to the Canadian Charter of Rights and Freedoms in its preamble. On the eve of the election, the Progressive Conservative government said, oh, that's outrageous that anyone would object to that. Of course we're going to put that in. And the Wildrose said, no, we shouldn't do that. Interestingly, after the election, the Progressive Conservative government succumbed to the Wildrose and, again, those extreme arguments, and agreed that, no, it might be a little offensive to have people in our education system ever feel that they might be needing to follow the Canadian Charter of Rights and Freedoms. And now we have this. We have this attempt to eliminate Section 3 sub 1 sub b. Now, I will acknowledge that this section is not without its complexities, that it is not without some difficulties in terms of its interpretation and in terms of its implementation. That may well be true. But the way to deal with that is not to simply sever it and arbitrarily move forward with, I would suggest, empty rationalizations that all of this can be taken care of by the Criminal Code of Canada, because, be clear, my friends, it cannot be taken care of by the Criminal Code of Canada. So, and it's interesting, the classic example of how this section has been potentially less than effective is the Lund case, which the Justice Minister referred to. And I found it particularly interesting because people got so involved in that case because of what I would argue were the very extreme opinions put forward on it by Ezra Levant. And I got to say, folks, choose your friends wisely, man. I just don't know that that's who needs to be driving your public policy decisions. That being said, he has every right to say what he does say, as do we all. But there is a limit on every right. Now, interestingly, when the Harper government chose to eliminate Section 13 from the 13, not 30, from the Canadian Human Rights Act, the Canadian Bar Association came out and said exactly that. You know what? Every right is only meaningful to the extent that it is limited in the appropriate circumstances, and no right in our country is absolute. And indeed, that is what the Supreme Court of Canada has said about the right to free speech. Again, it is important, but not to the extent that it infringes on someone else's ability to feel safe or secure. And that's what this legislation is geared to achieving. So, let's talk a little bit about whether the removal of this section could be ameliorated by the existence of the hate crime provisions in the Criminal Code of Canada. Well, first of all, no, because the standard that somebody who is the subject of a hate speech needs to meet under the Criminal Code of Canada is much higher than the standard that someone who is the victim of hate speech needs to meet in, through the Human Rights Code or the Human Rights Commission. Secondly, the Criminal Code of Canada has a very specific remedy, and there's not a lot of discretion in it. You convict someone of a crime, you come down on their head like a big hammer, and that's it. Whereas the Human Rights Commission, if it's properly funded, if it's respected by the government that administers its legislation, which is a whole other issue in this province, but nonetheless, if that is done, then the Commission has the capacity and the discretion to engage in restorative justice, in mediation, in efforts to work through those problems that often exist between what is most often just a lack of understanding between two different minority groups within our society and within our communities. So that's another reason. A third reason why the Criminal Code of Canada won't work is because that particular mechanism, frankly, my friends, is much, much less accessible. It is something that is engaged upon at the discretion of the police, not by the victim of the hate speech. So again, it doesn't work for that reason. Finally, the Calgary police themselves report that in their estimation, they only hear about 34% of hate crimes and hate speech offences. So that's what they're hearing about. So is that really the place to go? Are they going to have the time and the resources and the effort to do the work that is necessary to grow inclusion, to grow acceptance, to grow mutual understanding in our province? No, that is not the job of the police, and it is not the job of the Criminal Code of Canada. It is something that should be happening through our Human Rights Code, and that's why our Human Rights Code needs to continue to be respected, and why this provision needs to remain inside our Human Rights Code. Now, in December 2012, Racism Free Edmonton held public consultations on these issues, and they reached out to people from different minority communities, a broad range of different minority communities. And I have this wonderful list of the organizations that are represented here in the galleries today. And of course, being who I am, I have misplaced it in a pile, which is irritating to me because I wanted to read them out because they are so diverse. They represent ethnic minorities, they represent sexual orientation minorities, they represent gendered minorities, they represent income minorities, they represent a broad range of minorities. But those folks came together and they concluded that Section 3 in our Human Rights Code continues to serve a very, very important purpose in our province, and that its removal will result in more discrimination, more discriminatory acts, and less opportunities to resolve those issues. So that's what they've said, and I think we should listen to them. And that is another point that I come to here. Here we have a motion by the official opposition who think they might get enough support from their right-wing leaning pals over in their little, in the family. Let's face it, it's all big families between those two. Think they might get enough support for this. And then suddenly, boom, if that happens and the government acts on it, we're just going to eliminate that section of the Human Rights Code. Now, the fact of the matter is even though this is a complex issue, and even though it's never easy to balance two rights under our Charter and under our Constitution, the fact of the matter is where you start that process is by consulting by consulting heavily with the interested parties to this. We need to bring in members of all of these community groups on all sides, not even those who are the victims, but also sometimes the perpetrators, and that hasn't been done.
Thank you, Honourable.